Righto. Contractual mistake comes in three flavours. You have common mistake, which is rare. You have mutual mistake, which is exceedingly rare. And you have unilateral mistake, which is outrageously common. Maybe not the right word. Happens a lot. There are three flavours to this type of vitiating factor. And those three types are common mistake, mutual mistake, and unilateral mistake. And I'll go through each in turn over the next, what have we got, about 40 minutes. But just make note from a practical point, again, we'll assess you as if these have equal weight, but in real terms, common mistake is very, very, very rare. Mutual mistake is almost impossibly rare, and unilateral mistake happens all the time. And the reason for that is that common mistake occurs where both parties are equally mistaken about the same subject, or something fundamental to the contract, and both parties are equally mistaken in relation to that. Mutual mistake occurs where there are two subjects. The parties are somehow at cross purposes. I'm talking about this particular subject and you're talking about that particular subject, and somehow we've managed to create a contract. You can imagine in your head how difficult that is actually to do. And unilateral mistake happens all the time. Why? Because it happens all the time that two people enter into a contract and one side is mistaken about something fundamental to that contract and the other side is not. That happens all the time. And as you could imagine, there's two subjects. Mutual mistake happens where there are two subjects. I'm not mistaken about what I'm thinking about. You're not mistaken about what you're thinking about. They're just two different things. Common mistake is the first one where there is one thing and we're both equally mistaken about something fundamental to that thing. Okay? Now, if you go through Steve's book, and I hate to start the subject, Steve, who's my PhD supervisor, who's taught me many, many subjects, and literally lets me help him edit his book. There is one part in this lecture which, just in terms of structure, I'm not convinced. Not convinced from a practical perspective. People would be able to actually argue it much in court, which I'll get towards the end, which is to do with unilateral mistake. But the first two are pretty well established principles of law. They're old. And it goes like this. If the parties to a contract are actually thinking, both of them, are thinking about something and they're both wrong, and it's fundamental to that contract, there is no contract. I'll start that again. If both parties come to a contract and they are fundamentally mistaken, both fundamentally mistaken, either that they're mistaken equally about something fundamental to that contract that turns out to be different to what they both thought it was, and they never thought about it or mapped it out and made it a term, there is no contract. There was no meeting of minds. Right? That's really what mistake is about. It's about something that really goes to the heart of a contract. That means that there's no true meeting of minds between the people. Am I sufficiently loud, by the way? I'm trying to crank it up. And we learned about terms last semester. One thing about terms is that if you map things out, that, you know, if this particular subject matter doesn't exist, then X, Y, and Z happens. We've already contemplated it. That can never be mistake. The parties have actually gone and thought about what's going to happen if the thing either exists or doesn't exist. It's not outside the scope of what the parties contemplated. A mistake can't apply. Okay, that's a really important thing. And again, while I say you guys won't be assessed on anything really flowing from contract A, knowing what terms are is really important. So that component of learning and knowing what terms are is important, and knowing that if we put a term in the contract that something will happen. One side or the other side promises to do something or forgo from doing something or gain some benefit or suffer some detriment from that particular subject matter existing or not. That's a term of the contract. You're going to have one winner and one loser. Most of the time it's the person who wrote the contract and made the other person liable, but mistake won't apply in that situation. So some examples. And really, it goes back to one of these three things in terms of common mistake. Existence of the subject itself. I actually set this as an exam question for my MBA students, and I think one person in the class got it right. Existence of the subject matter before the contract is formed. All right, existence of the subject before the contract can render a contract void for mistake or common mistake. Both parties think that the thing exists and it doesn't. Common mistake can apply, rendering a contract void. Ab initio. Ab initio just means from the beginning or from the outset. Okay. If, however, the same thing is destroyed after the time of formation, all right, there are other doctrines that apply. It's actually the doctrine of frustration, we'll do later in this subject, can apply, assuming the parties didn't map out existence of the subject matter as part of the contract itself. Bell and Lever Brothers. Lever Brothers is actually the old name for Unilever. It's a big conglomerate. It prides itself in being a conglomerate of lots of fingers and lots of pies all around the world. And so that particular case is from the 30s, I think. It might have actually been in the 20s, but it was heard in the Privy Council in the 30s. It involved a guy, Mr. Bell, who was given a golden parachute. Do you know what golden parachutes are? They're a big pocket of money. Big packet of money, that people are given when they leave. Usually people like CEOs and company directors. We'll get rid of you and give you a big packet of money. And so that's what they did for this guy Bell. And they gave him a big sum of money. It was like £30,000, which in the 1920s was a very, very large sum of money. Him and I think his mate as well. To tell him to bugger off. But turns out they'd been very naughty. They'd actually gone and done some unlawful cocoa trading somewhere. And so it turns out that they'd been in breach of their employment, and so Unilever, or Lever Brothers would say, didn't have to pay them that sum of money. They were mistaken about the fact they needed to pay them. Both sides were mistaken. Mr. Bell thought that they needed to pay him, and Lever Brothers thought they needed to pay him. Turns out they were both wrong. In that particular set of circumstances. The court in that case didn't take they took a pretty narrow view of what was going to require something to be common mistake. And it in that situation, it wasn't actually, I don't think it was actually found. But they did go through and map out what is required in order to prove something. It's a pretty high bar, because it has to be something that's well outside the scope of what the parties have contemplated. Okay, and as I said, the existence of, in this case, of I guess it was a contractual right or contractual obligation to do something, to pay a sum of money. In that case, it wasn't going to be sufficient. In other situations, it can be to do with some fundamental quality. I didn't put the word fundamental in there, but certainly Lord Denning in Leaf and International Galleries made the point that for something to be rendered void, a contract, and you guys probably were, Rachel probably talked about this, courts of common law, the courts of ye old England, they bend over backwards to make sure that contracts are upheld. They will go out of their way to make sure, or to try to render something that a contract exists, in order to actually analyse what the rights and remedies of the parties are. And so vitiating factors like mistake kind of work around that. They work against that. And so what Lord Denning said in Leaf was the quality has to be absolutely fundamental to the thing. And in Leaf and International Galleries, guy bought from an auction house a painting of a cathedral, Salisbury Cathedral, by a guy called John Constable. Except it turns out it wasn't by John Constable, it was by some guy called Bob Constable. So it was signed with Constable on the bottom. And there the courts actually said that, look, well, yeah, that seems like a pretty important thing. And yeah, you probably wouldn't have paid that amount of money if you knew it was by Bob Constable and not the famous painter John Constable. You've still got a painting. It's a lovely painting. And it's by some person called Constable. It's not good enough. That wasn't fundamental enough to actually render that contract void ab initio. Courts don't like doing this. No, the void, seeing it or not seeing it doesn't matter in that situation. It's about being mistaken. So they were both mistaken. I want to buy a painting that's a constable. And like that, he got a painting that was by a constable. Look, Leith, there's a bunch of cases you'll hear, particularly Lord Denning, suffers a little bit of criticism in terms of people going back over this and trying to work out what he's going on about. And there's another case here, Lien Butcher, which has rendered the law in Queensland and Queensland only a little bit awkward in relation to common mistake. But again, it doesn't come up very much. In Leith and in a lot of these cases, they actually argue multiple causes of action. It's something that you guys, as you start to read more and more cases, you'll realise that this one's pretty hard to prove. And if you're going to go all the way to court to do something, you fire a shotgun, not a sniper rifle. If we don't get up in this, he tried to argue that it was misrepresentation. The auction house, for example, in that case, somehow, even innocently, deceived him. And they said, no, it took too long. He tried to argue they were in breach. It was an implied term of the contract that having it being a constable was part of it. So they tried all of those things, and Lord Denning, very kind of unhelpfully, didn't even get up on any of them. There is one part, though, where the courts are a little bit happier to go through and look at, and that's the recording of intention. You would have studied Cadalpha in the State Railway of New South Wales. What's the test for looking for the intention when you're trying to determine what the terms of a contract are? Does this sound familiar? The objective intention test? It's not about what I thought, it's not about what you thought, it's about what a reasonable third person would think their contractual obligations are. It's a pretty important role. It comes from Justice Mason and Cadalpha. And sometimes both parties can come together, have a meeting of minds, and then they're both equally mistaken about how that was written down. And again, the courts can come to some form of remedy in terms of doing that, including the remedy of rectification, which I think I talk about here. So, number one, existence of the subject matter. Taylor and Caldwell was a case where somebody was contracted to sing in a big music hall. All right, unbeknownst to both of them, the hall had burnt down. The hall didn't exist. Neither party thought about it. Neither party knew about it. Neither party mapped it out anywhere in the contract. But it was utterly fundamental to that particular contract. And as a result, there was no contract. There was no true meeting of minds. We couldn't have a contract for something that did not exist. Good case, one that I like is this. Is the first one on the next slide, which is McRae and the Commonwealth. It's from the 50s. Involved salvage operators taking the Commonwealth government to task. It's McRae and the Commonwealth Disposals Commission, and basically he was given or paid some money, not a huge sum of money, I might add. I thought it was a lot. Turns out it wasn't much, but had to go and spend a lot of money to try and recover oil from a tanker somewhere off the Coral Sea. I don't know whether it was actually something that sank during the Battle of the Coral Sea. I should go back and check. Originally I thought it was, but it might not be. Anyway, there was an oil tanker on a reef, and you had to pay a sum of money, not a big sum of money, to get the exclusive right to go and get that oil, to salvage that oil. And it's quite a tricky thing to do. In the ocean, get the pipes down, grab the thing up. And so it goes and does this. What was the problem? There was no tanker. In fact, there was no reef. Commonwealth Disposals Commission was mistaken. And so was Mr. McRae when he went into that contract. But the courts there were pretty heavy on the Commonwealth in terms of this particular instance, and they said that, look, here, even though if neither party had contemplated the existence of the reef itself, right, in this particular set of circumstances, we can actually imply a term. And you guys would have learned the rules for implied terms, things in terms of something that has to be so obvious it goes without saying, is necessary to give that particular contract business efficacy. And that situation, the courts were not willing to find common mistake, or they weren't willing to find there was a contract. What they did say is that in order for that contract to have any meaning, you, the Commonwealth, actually somehow, in some way, promise that this thing exists. They implied the term in that situation. Tanner and Caldwell just mentioned just before, that was to do, I don't think it was somebody singing, I think it might have been the hiring of the hall, and the thing had burnt down before the time of formation. If it burns down afterwards, there are still consequences, but those consequences are not common mistake. And that can make a big difference. Because if there is no contract, you've paid money. I've paid money to go rent this hall, and there is no hall, and the courts are happy to say there's common mistake. This is my money. And it's important to do with things, assets. And it used to be things like cars before we had systems of registration. If somebody gone and sells a car, and it turns out that the contract is void from the outset, it's still my car. I have your money, you have my car. I'd like my car back. And that can matter, particularly in situations where one or the others disappeared. The money's gone, but the car's still there in terms of who gets to grab it. What's the last one? Oh, Maralinga. Yeah. If there's an asymmetry here, if there's a situation where one person knows about it, or knows about the existence or the non-existence of the subject matter, it's in most situations, that knowledge, particularly if it's material to the contract itself, goes to the heart of it, is actually going to be deemed just a breach. The knowledge that they have, much like in McRae, it's going to be implied that existence is a term of the contract, and you're going to be in breach as part of that. You are representing in some way, promising that that particular thing exists as part of it. If you know and the other side doesn't know and they've got no mechanism of finding out. It's if one side knows, it's not going to be common mistake. Look, other areas can come up, because we're going to go through all of the vitiating factors. It can be something, misrepresentation might apply, there might be some misleading and deceptive conduct, there might be some other areas of law, but common mistakes are a pretty high bar. It's pretty hard to go through and prove. Parties have to not talk about something that goes fundamental to their agreement. And if you think about it, it sounds almost silly when I say that. Something fundamental to what we're doing, but we didn't talk about it, think about it, contemplate it. And there's no asymmetry in terms of the knowledge between the two. It's pretty rare. Okay, Sound of Goods Act actually enshrines that. Sound of Goods Act, it's an interesting little act. It's only tiny. You think, Sound of Goods Act. And the purpose of that act, by the way, it's very old. It's from the late 1800s. And it was to enshrine a bunch of the common law rules at the time into an act so people could read them. It's very easy to read. You guys don't actually have to study it. Up until last year, I think this year, or it might have been last year, it was mandatory subject. It was a priestly subject, and these days you guys don't need to study it. So it's possible this subject's the only time you're going to be exposed to this. And so we'll go over that in a little bit more depth in, I think, week 5. But just make note, they just have rules that say each one of these things has a particular meaning. Specific goods has a particular meaning. But it does make note, goods that have perished before, so before or at the time, is going to be void ab initio. Where it's got the are voided, that gives the other party the right to go through and do that. All right, the language is a little quirky. The language is over 100 years old. But that thing that I mentioned before, this right, sometimes we call it the right to rescind, the right to render a contract void. And you'll see it in different texts and different judges. The right to undo a contract. All right, that means the contract is voidable. One side gets the right to do that. They use slightly different language in each time. it's not actually a big deal. They're really meaning the same thing. That's really what that means there. Yeah, well, when you've got goods, if goods and have gone and they've perished, that's pretty much it. One side is, and with all of these things, all of these causes of action that we have, both in tort and contract, and land law and trusts as well, it's about where the money is. We, as the lawyers, want to assist our clients to get the best result. The best result is often either to get money from the other side, or if they've got no money, get the goods back or the stuff back. Here we're dealing with the goods that have perished, so we're just after the money. We want to prove, if we are the seller, of goods, we want to prove that title has passed, because we want the risk of perishing to be with the people that have bought it. We want the risk. Once they've got it, it's in their hands and they own it, it's their problem. And so you do get a little bit of that. It just comes across as really nasty. Sometimes it does a little bit. We try and think about what's best for our particular client. I mentioned before about Leaf and Bell and Lever brothers. Lien Butcher is something of a problem. Lien Butcher involved a case involving rent, I think it was, during the war, and the lowering of rent because they thought the rent controls were in place. And Lord Denning, in his infinite wisdom at the end of it, said that, okay, here the parties are mistaken about something, and it's a particular quality of that particular contract, but it falls short of rendering the contract a void ab initio from the outset. But the circumstances of the case give rise to right in equity to be able to give one side the right to undo it. Equity gets to step in to remedy the defects of the common law. There's a good argument that that's wrong, which I'll get to later in this lecture. But that's essentially what he said. And so when you read in the text, and you read, particularly in Steve Grove's book, you'll read about that idea that, look, a simple quality follows, a common law won't render a contract void, like in Leaf and International Galleries. You got your painting by Mr. Constable, not a very expensive painting, boo-hoo, somebody has to bear that loss, it's still a contract. And Lord Denning said in Lien Butcher, it was just after the war, that actually in some situations, the court of conscience will step in, give the innocent party the right to undo that contract, to preserve or create some sort of injustice. But there's some problems with that. That's right. Or the quality, or usually the particular quality of the thing is whether or not the Rent Controls Act in that case applied or didn't apply. Because if the Rent Controls Act applied, the rent is, legislation steps in and makes it artificially low. If it didn't apply, then you didn't have to. You could pick whatever rent you like between the two parties. During the war, or the UK government jumped in and said, look, buildings are getting bombed all over the show. We better have some sort of regime in here, otherwise it's going to be a real problem because people are going to have to move. And so we're going to put some controls in that people can still get rents, but they're going to be lower and they're going to be fixed for the duration of the war, just to save a whole bunch of hassle. Okay. How much time we got? 36. So when the two sides come together, have a meeting of minds, agree that they're going to put it in writing, and then somehow there's a mistake putting it in writing, usually the courts can give effect to the objective intention of the party, assuming you can prove it, and actually go through and rectify a contract one way or the other. What can be the problem with that? Well, usually there's going to be one winner and one loser. And rectification, fixing a contract by the court, is an equitable remedy. It is not a common law remedy. So again, the doctrine of clean hands, latches, these all apply. Taylor and Johnson is actually the case for unilateral mistake. So we'll go back up this a little bit later. Is the a situation where there was a contract and it was for a lady was selling some land for 11,000. No, it might have been 7,000 per acre. No, it was 11,000 per acre. That's right. Was it so 1,500? 1,500 was some amount. It was 4 digits anyway. That's it. And she thought, and the land was worth about 6 or 7 times what. Oh, sorry, let's start again. Was it 1,500 in the what she thought, and it was 10 times for the lot. That's what it was. Okay, so it was 1,500, and the land was worth somewhere in between those two extremes. It was basically, she thought she was getting a good deal, and he thought he was getting a great deal, the purchaser, because he'd read the contract and he knew that it was for $1,500 for the whole lot, not per acre. She was mistaken, and he knew about it, and he actively took steps to prevent her from finding out. And the courts in that situation, it went all the way to High Court, stepped in and said, equity will step in that situation, and they will prevent this injustice from occurring. And now one of the ways they'll do that is to fix the contract. Okay. And just make note, there's a temporal thing there as well. If rectification is awarded, then it's considered to have been rectified from all time. All right, how we got? Just really quickly, in electronic contracts, that is way too hard to read. It's that's 15 capital D in the Commonwealth Act. If you're going through and you've made a typo, and there's no way of correcting the typo, you can get a remedy there, and that is to either rescind or somehow undo that contract. Depending on what the particular part is, you're given the opportunity to go through and amend that thing. By default, the contract will stand, but you're always given the right to change the bit where there's a typo. So if you're filling something in, and that's why you go and you buy something at an auction, or you purchase something in eBay, Jetstar. Oh, I love Jetstar. We have some good examples of that, again, for the MBA subject. You can't ever negotiate with Jetstar. When you're doing it, if you make a typo, you can call them up and say, fix this typo. I made a typo. There was no mechanism for me to undo it. Therefore, I want to rely on this section of the Electronic Communications Act. This is quite recent. It's only a few years, been in for a few years. I mentioned before about Lien Butcher. Lien Butcher was expressly overruled. Unfortunately, Lien Butcher was followed in Australia in 1956, and that's Vasnino and McNamara. So it was the law of all of the jurisdictions in Australia. There was a case in 1999 called it happened in 99, but the case was a few years later, of the Great Peace Shipping and Sutters, they're hard names, Sadvirus. They said, Lord Denning was wrong. There is no such thing about using principles of equity to somehow render a contract or give some party the right to undo a contract. That is just a simple misstatement of the rules of equity and the common law rules of contractual mistake. Other forms of remedies might be available, misrepresentation or a breach of contract, but not that one. And kind of unfortunately, the Queensland Court of Appeal, in a case about 10, 15 years ago, the Australia Estates case, actually followed Great Peace and not Lien Butcher, which is a bit of a problem because it means that at the moment, in Queensland anyway, you can't rely on equity to give you the right to undo a contract where some injustice is going to occur, where something, some quality which is not quite fundamental enough to render it void ab initio at common law, but nonetheless create some injustice. Nah, not in Queensland. That's something of a problem, but these things don't come up much. It's very rare these things end up going to the Superior Courts. It's been 15, 14 years. I'm not expecting one in the next 14 years. All right. I mentioned before about this kind of quirky difference. When we think about McRae and the Commonwealth, where both parties are arguing, or the Commonwealth was arguing, that both parties were mistaken. There was no oil tanker. There was no reef. Or the rent control in Lien Butcher. Both of us thought that the Rent Control Act did apply. Or we thought that the Hall and Taylor and Caldwell was in existence. Turns out none of those things were right. But at least the arguments made by the parties were that both parties were equally mistaken. We both thought that that music hall was in existence. We were both wrong about the same thing. We made the same mistake. That's common mistake. Mutual mistake is where there are two subjects. And I'll gloss over this because, what's this case? Raffles is from 1864. Haven't been many since then. That involved a contract for a shipload of cotton, leaving, I think it was Mumbai, in a boat called the Peerless, Peerless, Peerless. What was the problem with that? It turns out there were actually two boats called the Peerless with a shipload of cotton leaving Mumbai. One was leaving in June, one was leaving in November. I mean, okay, things like that do happen once in a blue moon. And there, the contract is much more common. The contract's void ab initio. We're talking about two different subjects. Assuming that can be proven, there is no contract. No contract. The rights of the parties and goods title can't pass. It's pretty rare. But what's not rare is this guy. Yeah, that's mutual mistake. There's the same boat, well, different boats, same name, same cargo, leaving the same port. How unlucky is that? And how unlikely is that? The example that we usually use is things like you've got a blue Mitsubishi, and you say, "Oh, do you want to buy a blue Mitsubishi?" And I've been driving past your house. You've got this awesome, Evo 5 Lancer out the front. And I'm like, "Yeah, I'll buy that. 10 grand, sweet." And then you arrive, and they take you out the back, and there's this rusty old blue Mitsubishi Magna sitting out the back. There you go. Here's your car. I thought it was the Evo. No, I was meaning this one. And so that again, it seems like I'm really, really stretching to try and come up with a scenario as a result, because they don't come up much. These things come up a lot though, and usually one side's going to lose out. Usually it's the side that's mistaken. I mentioned Taylor and Johnson before. That's a case. Equity will intervene if it's going to cause an injustice where one side knows about the other side being mistaken and actively takes steps in poor conscience to stop them from learning of their mistake. But there are some ye old England cases, very unfortunately, involving mistake in terms of the identity of the person. This law is quite unsatisfactory. This is something that I said, I'm not sure Steve has updated his book recently on it. I think you'd have a really hard time arguing this in Australia, and the Poms actually had a chance to go and map this out. The Shogun Finance case. Okay, but there's a rule you need to know before I talk about this really quickly. It's called the Nemo-Dat rule. And that is, when you sell something, well, think 50 years ago, something like a car. These days you've got systems of registration, leaving that aside. But when you go to sell something, the person who's acquiring the thing can never acquire better title to that thing, better ranking in terms of ownership than the person selling it. So if I go and have a car, and again, leaving aside the registration stuff, and I sell it to Leanne for $10,000, but it turns out money was still owed by the previous owner of the car that I'd got it off, or there was I had a hire purchase agreement and I was in breach of that. So it was strictly speaking owned by the finance company. I've sold the car and then I've disappeared. I am the rogue. I've taken the money and disappeared. What's the problem? Well, there's the finance company and there's Leanne and there's the car. Who gets to keep the car? It's the finance company, because the Nemo-Dat rule says I didn't have the power, common law, to pass good title when on selling that thing. It's an important rule with the Sale of Goods Act. You can't give better title when you're on selling things than what you have. So these cases can be very, very unsatisfactory. Cundy and Lindsay involved handkerchiefs. And in that situation, the parties weren't face to face. It was a rogue came in and pretended to be from another vendor. All right, pretended to be from another vendor purchasing handkerchiefs, took the handkerchiefs, disappeared. And the courts there said that actually, unilateral mistake does apply. We will render the contract void because the identity of the particular entity coming into it was fundamental to that particular contract. It sounds a little weird while I'm saying that, and it is. It is a little weird. And Shogun Finance, a guy called Mr. Patel came in with driver's license and came in with all sorts of identity documents, bought a four-wheel drive Land Cruiser, I think it was. No, it was a Mitsubishi. It was a Mitsubishi Shogun. Bought that vehicle, claiming to be a Mr. Patel, and the finance company argued successfully that they intended only to deal with the real Mr. Patel. And so as a result, they still owned that particular vehicle when it went off to Mr. Hudson at some stage later. Pretty unsatisfactory case. Not sure that would apply if that goes to the superior courts. This went through the courts these days. Because the flip side of that, if there's a face-to-face transaction, by default, you're assumed to not care. The person who you're dealing with is the person you intend to sell that thing to. And so some guy tried to argue this. Lewis and Avery was a case where some guy rocked up with a wallet and claimed to be Mr. Richard Green, who apparently was some famous movie star who played Robin Hood many years before. Bought this guy's Mini, took the Mini, disappeared. I think wrote a check out and the check bounced. You guys are probably aware, a check that bounces, you know what I mean by check bouncing? You write a check out and there's no money associated with it. That is what's called a total failure of consideration. All right, you cannot pass good consideration as part of that. And so as a result, when you're going through to try and determine who owns this particular vehicle, Mr. Avery, I think, tried to argue, I intended to deal with only Mr. Green, Mr. Richard Green, the famous actor. And the court said, nah, mate, you intended to deal with the person right in front of you. That's the nature of this very, very unsatisfactory area of law. It's a bit of a quirk in our system. Okay, just before we go, 5:50, got 10 minutes. There's two more things I've got to say. Yeah, two things. All right. The first, in this day and age, is pretty rare. If you go back 200 years, not at all rare. And that's the non-est factum rule. We put it under mistake because it only applies where there is a functionally illiterate plaintiff. You have to be functionally illiterate to not be able to read a particular document, and you've taken reasonable steps, reasonable care to determine the contents of a document, and then you've signed it, but it turns out to be fundamentally different to what you thought you were actually signing. That will render a contract void. Strictly speaking, I guess it's a unilateral mistake, but it just renders the contract void ab initio. And this is a common law rule. Why is that relevant? Remember, equity doesn't like him, really impeding on the rights of third parties. Non-est factum will impede on the rights of third parties that, innocently go and take things, expecting this to be a valid contract that they've relied upon. Equity won't intervene. Look, it's pretty rare. Functionally illiterate people are a bit of a minority. They do appear. Again, person done community legal. It is still a thing, but it's harder and harder, and it's a pretty high bar to prove. All right, the final slide is the guiding principle. I like this. The guiding principle of contractual mistake, which is, and I used to refer to it a bit tongue-in-cheek as unilateral mistake, being the doctrine of tough luck. If you're buying something and you're mistaken about it and the other side's not, too bad. Tough luck. Caveat emptor means let the buyer beware. Take the time to look at things. Put due diligence into doing things, and as future legal professionals, instruct your clients to do the same. Because trying to get things vitiated and rendered void through mistake, common mistake, mutual mistake, or particularly unilateral mistake, is a very high bar. And so while we've started with this in terms of the theoretical, the academic side of your education on vitiating factors, in practice, this stuff is pretty rare. As opposed to the stuff we're going to be doing next week, which is on misrepresentation, which is exceedingly common. And so I'll end it there if that's all right, guys. I said the recordings I've learned take about 4 minutes to actually finalize, and then they come up. So I've got to go through and change the names for some of them as well.